good afternoon, everyone. Thank you for joining us today. Going to kick it off here as we are presenting on our labor employment law updates for our employers and have a full agenda. So you will probably want to take notes. We'll have the slide deck readily available afterwards, as well as we have a lot of good stories, legal updates, federal and compliance updates for you today. And so lots of information. And so I am Kendra Hoffman. I am one of the co-presenters alongside Deanna Hayes. I've been with Puzzle as an HR director since almost the start of Puzzle, so have been at Puzzle for about 5 years, and am honored to be able to present with Deanna, who is one of our employment law attorneys that we work with at Ogletree Deakins, and have had the pleasure to work with her for the past couple of years as well. So Deanna, I will let you take it from here.
Okay, wonderful. And thank you so much for having me. I've really enjoyed working with you, Kendra, and with the PuzzleHR team. I'm going to share my screen so we can all see the slides here.
Right, as Deanna's getting it up, we have the chat box and then the question and answers section open today. I will be manning those and being able to answer them on the fly. Otherwise, we'll wait until the end to get any of the questions answered. So please use that chat function today with any questions that you may have come up as we are presenting.
Well, as Kendra said, we have a lot of ground to cover. I think that the government likes to keep us all on our toes. So there are many hot topics that we can dig into today. If you have questions along the way, please do use the chat box. We will be on the lookout there. And if we can't get to everyone's questions during the presentation today, we will follow up with you afterwards. So don't worry, if you have questions, we are here for you. So let's start with federal updates. And probably one of the biggest things on everyone's minds is the Federal Trade Commission, the FTC, and the recent vote to ban non-compete agreements. So a lot of questions surrounding this. What does it mean? What's the current status of the ban? So basically in April, the FTC did adopt a final rule that would ban the use of non-compete clauses and also require employers to proactively rescind any agreements that were in violation of the new rule. With the exception of existing agreements with senior executives. And the way that senior executive is defined is an employee in a policy-making position who also has an annualized compensation of over $151,000 and change here. So that's a pretty high threshold. Of course, we don't have a whole lot of guidance as to what constitutes a policy-making position. But certainly that position would want to have input on policies and procedures, at least to apply to the department that they work in or the team that they're managing, or be responsible for budgets, be able to make some decisions on their own. That type of authority would be necessary to qualify. It would also include an exception for non-compete agreements that were entered into as part of the sale of a business. And if this were to go into effect, it would take effect 120 days after publication. But it's already facing some legal challenges, So there actually have been a couple of different lawsuits filed in federal court in Texas. That seems to be the forum of choice when federal regulations are challenged. That is largely because Texas has conservative, business-friendly courts. So when advocacy groups and industry groups file suit, they look there because they believe that they will have a better chance at a favorable outcome for the businesses. So you might have heard, I think the lawsuit that got the most press was filed by the U.S. Chamber, but there was already another industry lawsuit in place. So now the Chamber has joined in that lawsuit, and there's just one lawsuit that's pending in Texas. With the briefing schedule, the court has said that it will review the briefing and decide whether a hearing on the motion to enjoin or stop this rule from being enforceable is necessary. And if there is a hearing, then that will be held on July or the end of June, and we'll have a decision on the merits either way, regardless of whether there is a hearing on July 3rd. So the short answer on the timeline is that if things go as currently planned, we will have a better idea by the July 4th holiday of whether this rule is going to move forward. Kendra, have you gotten a lot of questions on this one?
We have, and it's one of those things that's kind of a wait and see. Non-competes are used very frequently with all of our clients, and so it's a common question on will it really stand? What should we do? Should we wait? So that's kind of the questions that we've been asked right now, and really kind of giving guidance on what they should be doing between now and really that July date.
Absolutely. And I think it's a good idea, if you haven't recently reviewed the template agreements that you're using, to take a look at them and see which agreements actually have true non-competes. Some employers have moved away from true non-competes, and instead they're using non-solicitation of customers or clients or patients, or non-solicitation of other employees that are employed by the organization, or in combination with a non-disclosure agreement that prevents disclosure of confidential and proprietary information. So if this rule does go into effect, then I think we'll need to keep watching to see how this is going to be interpreted, as far as, are those other types of restrictive covenants, non-solicit, non-disclosure, still going to be permissible? And the FTC right now has said yes, provided that they don't in and of themselves prevent someone from going to work for a competitor, because that's really the goal. I mean, if they could still work in the industry without disclosing the confidential information, or without having to call upon that same set of customers or prospects, then arguably they should be okay. We'll just have to wait and see. So another big rule that has gotten a lot of media time has been the increase to the minimum salary threshold for overtime. And you may have heard that this one is also being challenged in federal court. That lawsuit was just filed on May 21st, also in federal district court in Texas, the forum of choice for these type of challenges. And the plaintiffs there are the same industry groups and folks that filed suit the first time under the Obama administration, when these thresholds were first proposed to be increased. And they said, hey, court, why are we here again? We're here again. We're being forced to litigate the same thing because the government is at it again. So our former arguments still apply here. This is a huge increase. It's not justified in the act itself. And there are some other pieces of this kind of current rule that make it ripe for a challenge. The first is that it's a two-step rule, which you may have heard. So beginning on July 1st of this year, the minimum salary would increase to $844 per week, or $43,888 per year. But then it would increase again in just 6 months on January 1st, 2025, to the equivalent of $58,656 per year, which is a huge increase tied to the 35th percentile of salary in the lowest wage census region in the South. And if you kind of were embroiled in the challenge to the Obama era proposed rule, then you'll kind of recognize that number. That rule was going for 40th percentile. So this is very similar with 35th. And again, the plaintiffs are arguing that, hey, this was invalidated once before, it should be invalidated again. And for comparison, under the Trump administration, even though there was an attempt to raise the minimum, it was only to the 20th percentile, so much lower of a bar. Also, interestingly, this rule incorporates an automatic increase to those numbers every 3 years. So that's another piece of this that's ripe for a legal challenge, because the FLSA itself does not have any kind of automatic increase incorporated within it as it was originally written.
It would also big numbers, and I was going to say those are some big numbers and some big jumps, and it'll be interesting to see kind of where this one lands as well.
It will, absolutely. And I wish I had a crystal ball, but it is true that this court looked at this issue before and decided that the rule should not go into effect. So it is possible that the exact same course will be taken. It's also possible that there could be kind of a hybrid approach where step one is approved, but step two and the automatic increase going forward are struck down. So this is one that you definitely want to keep watching. It also increases the minimum threshold for highly compensated employees. So if you're using that distinction, just keep that in mind. And as far as what you should be doing now, it's kind of like with the non-compete piece, take a look at what you've got right now and make a plan. You may not want to implement it right now or next week, but it is a good idea to take a look and say, okay, how many employees do we have that are actually going to fall under the step one increase to that 43,888? And take a look and see, and look at not only just like the employees, but the job titles. As some employers are identifying, okay, these are all the job titles that we have where we have an employee that would fall below that threshold. And if you've already got some employees in that same job title that are way over, then you may say, okay, we're just going to go ahead and bump the lower end of that range to the new minimum so that everyone in this job remains exempt. However, if you have a job title where everyone is going to be below, take a good hard look at the job duties. Even though those didn't change, it may be that this role was not properly classified as exempt in the first place. So you may want to look at reclassifying just because you don't want to raise to the new minimum, or maybe a combination of you think it's a better fit for how the job stands now, because we all know that jobs change over the course of time. And that's another reason to make sure that our job descriptions are up to date as well.
Yeah, thank you. Thank you, Deanna. I think too, going back and even reflecting on job titles, that maybe the job titles have evolved. Maybe they need to be reviewed as well. At PuzzleHR, we have created an auditing tool. So we're going through and ultimately identifying the employees that would fall under as of July 1st and then as of January 1st to identify what that would look like, what the potential cost could be to the client, and then also going through and identifying based on job duties if they should be looked at per the exemption rule. So yes, I remember the Obama administration. I think it was 2016 possibly. And I think they came down to about 24 hours before the deadline that we got our update. So it's kind of a wait and see game then as well. And so had our plans in place to be able to determine what our steps forward would be based on that timeline. But again, it was about 24 hours before the deadline that we got any update.
Absolutely. Nothing like, waiting till the last minute. And I think a lot of employers, because it got so close, just went ahead and made the changes, right? Because it was so close to coming into fruition. But now that we know that's a possibility, I know a lot more clients are saying we're going to be willing to wait it out and see and be ready to pull the trigger if this does stand, after July 1. So we'll all be watching. And just a reminder, if you do have employees that are very close to that new minimum and they're paid any type of other incentive pay, such as an announced non-discretionary bonus plan or commissions, that can constitute up to 10%. So it can be their salary plus that incentive pay if it's kind of announced on a guaranteed basis, provided that they meet certain parameters to fill that other 10%. So that has helped some clients be able to just meet the minimum if it does stand.
All right, we did get a question in that I'll answer just live. So is there somewhere that lists the job titles this change is referring to? And so it ultimately comes down to the job duties, to understand what the duties of the role are, to see if they are falling within the exemption rules to be an exempt role versus just the job title itself.
Correct. All right. And while we're on this subject of wage and hour and compensation, just to be on the lookout, if you are a federal contractor, that there is a new proposed rule. So it's not in effect yet. It's just something to continue watching that would require federal contractors and subcontractors to disclose salary ranges in job announcements. And it would also prohibit them from considering an applicant's compensation history and making employment decisions. So this would be a huge change on the federal level if this does move forward. And on the state level, you may already be familiar with, there are many states that have gotten into the game and they already require pay transparency when it comes to job postings. And so we thought it might be helpful just to give you a quick overview of where those laws are in place right now, in case you're in those jurisdictions, or if you're recruiting from those jurisdictions, then it becomes important for you as well. And similarly, here is a map that shows the jurisdictions that currently have salary history bans where you can't ask for that information during the hiring process before an offer is made.
Deanna, question for you that some of our listeners may wonder. So if you're posting a position, you're open to a remote position anywhere in the United States, what is your recommendation for posting any salaries?
So it's probably going to be a judgment call, and you may even want to take a look and review, have you posted a position like that before? And if so, where are you getting your applicants, right? I mean, it is possible that you could get a candidate from anywhere in the country. So the most conservative approach would be to comply with the most restrictive requirement and go ahead and put that information into the job posting so that you wouldn't have an issue there. If you're advertising heavily kind of in one region versus another with a local industry group or an HR group, for example, then it's going to be more likely that you're going to get more candidates from that particular jurisdiction. So you want to make sure that you're compliant. It gets tough kind of with these one-offs in different states, but the risk is probably low unless you're getting a good amount of candidates from a particular area.
Thank you.
You're welcome. So another big topic that we are seeing are changes when it comes to accommodations that employers have to provide. And specifically, the first area that we'll cover are accommodations for pregnancy, childbirth, and other related medical conditions. So I just thought some of these statistics were interesting just to show how prevalent these issues are. I mean, most companies are going to have to deal with working parents at some point in the lifetime of their careers, but 72% of working women will become pregnant while employed at some point in their lives. So that's a huge number. And then I also thought it was interesting that 23% of mothers have thought about leaving a job due to a lack of a reasonable accommodation or fear of discrimination during pregnancy. So that's also a pretty big number. And these statistics are what the government has cited to as far as the rationale behind the Pregnant Worker Fairness Act. And really the theme is that it is designed to fill any gaps between the Americans with Disabilities Act and other conditions that employees might have that are related to pregnancy, childbirth, and similar conditions. So this one became effective last summer. It applies to employers with 15 or more employees. So the same kind of threshold number as Title VII. And what it says is that covered employers must provide reasonable accommodations to a qualified employee or applicants, known limitations that are affected by or arising out of, again, those three: pregnancy, childbirth, or other related medical conditions, absent an undue hardship on the business. So kind of, where this might come into play and how this is different from the ADA is that the PFWA recognizes pregnancy is a temporary condition in and of itself, which is unlike a disability. So an employee may be able to get an accommodation, even though we're talking about a temporary condition. And that also means even if they can't perform some essential job function, if it's just for a limited amount of time. And there's an express requirement for employers to go through the interactive process with the employee to determine, what it is they need. How long is it going to be in place? Is it for the duration of the pregnancy, maybe afterwards, or is it only for a limited amount of time? For example, some employees suffer from morning sickness early in a pregnancy that's really only going to impact them for maybe 3 or 4 months. And those employees might say, hey, can I start my shift 2 hours later in the day so that I can deal with any morning sickness issues that I have? That's something that probably wouldn't be considered a disability under the ADA, but it would be protected under the PFWA. Another unique component of this law is that if there is some other accommodation that is reasonable, like that shift change request, then the employer is supposed to grant that rather than just requiring an employee to go out on leave.
All right, we got a quick question, Deanna, in regards to that. So at any point of their employment, even if they're a brand new employee, they qualify under PWFA?
Yes. So it's not a leave in and of itself, right? It's just an accommodation standard. So it's similar to the ADA, right? So the ADA would come into play whether someone is just a candidate and is applying for employment, or they've only been employed for a short amount of time. So that's a really great question. And for the undue hardship piece, it's always, I feel like, the most difficult for employers to think about. But really, what you're looking for is what are some objective data that you could show if your denial is challenged, either by a charge of discrimination or a lawsuit, right? So, can we show that we just don't have the staffing levels to support the shift change request? Like going back to this example of someone who's saying, I'd like to start my shift at 10 a.m. instead of 8 a.m. because I have morning sickness. If there are no other employees available to fill that 8 to 10 a.m. slot, and the company isn't able to fill that, they've been recruiting, but no one's applying for the role, this person's the only one in the job, that might be an undue hardship because the business could show there's no way to accommodate this. We wouldn't have anyone to run the store or run the office during these 2 hours. Also, if it would be a significant financial hardship, if what the employee is asking for is significant, that could be evidence of an undue hardship. But the main things you want to keep in mind are, how would I document that I went through this interactive process and that I wasn't able to grant this request because it was an undue hardship. And I put a link in here, if you're not familiar with it, to the final rule itself. And also, I think it's in the next slide, to the EEOC's guidance and FAQs. And they really do give a lot of helpful scenarios. So if you haven't dug into this yet, I would recommend taking some time and reading through that so you have a handle on the kind of accommodations that the EEOC is going to say are probably reasonable. For example, they said if it's something minor, like allowing additional restroom breaks, letting an employee carry food and water in an area where they're normally not allowed to have that, if they need to sit or stand more frequently, need more time to have a snack, those are all things that the EEOC says most of the time that's going to be reasonable unless there's some real serious evidence why it wouldn't be. And while we're talking about Texas, right? So this rule has also been challenged in federal court in Texas, but only as it applies to the state of Texas enforcing this against its own employees. So even if you're a private employer in Texas and you've heard about this, you still have to comply at this time. And there's a similar law, the Pump Act, which has been in place longer, but they kind of work hand in hand, right? Because there is an undue hardship defense in the Pump Act if you have fewer than 50 employees and you're not able to provide someone with designated space to nurse or to pump. Then you still have to remember the PFWA, which is going to require you to make reasonable accommodations if you have at least 15 employees. So that's a smaller threshold than the Pump Act. So think about them kind of in conjunction with one another. And this was already built into the FLSA as far as the lactation breaks go and the space that would be suitable to provide them. So there wasn't a monumental change there. And the biggest update is to clarify that this is available to both exempt and non-exempt employees. Before, it was just contemplated that this would be available to hourly non-exempt employees. This is available for up to 1 year after a child's birth. And just keep in mind, if you are across the country, there are some states that have more stringent requirements, usually up to 24 months. So just be aware if you have any state laws that also speak to this where you're operating. And I've got some tips here on how to comply with the Pump Act. And really, this kind of goes the same for the PFWA, but just take a look at your policies, right? So if you haven't updated your policies in a while, go ahead and address lactation breaks. Tell employees how to request them at a minimum. Some states do require you to affirmatively say, that you're going to provide these breaks, where you're going to provide them, and who they should contact to request this type of break. Same thing for accommodations. I know, in the past, a lot of employers maybe had an equal employment opportunity policy that referenced accommodations or an Americans with Disabilities Act accommodation policy, but they didn't really also address pregnancy, childbirth, and related conditions separately. So if you don't do that, think about doing that as well so that employees understand that type of accommodation is available to them. And train your supervisors, right? Your frontline supervisors are typically the ones who get the first request from employees because they're the ones interacting with them on a daily basis. So make sure that they know that your policies have been updated too and who they should partner with. If it's a PuzzleHR team member or an internal HR team member, make sure they know who they need to go to so that they can get the right kind of response that they need.
Yes. I can't emphasize communicate enough on that Pump Act. I think based on kind of the inquiries that we get here at PuzzleHR, a new mother coming back to work, not really understanding what she's able to do, not able to do, not understanding where the space is, coming back and having to pump in a restroom. And so making sure that you are preparing first off, even if you haven't had someone go out on a maternity leave or coming back from maternity leave, but preparing, but then also communicating. So before they go on leave, they kind of understand when they return what opportunity or what's available to them and what their schedule could look like so they are able to express milk. So just really emphasizing that communication piece. And if you're not sure, definitely reach out to PuzzleHR or your HR department to see what you need to do to be able to be in compliance.
Absolutely. Those are great tips, Kendra. And also reach out too if you haven't updated your forms in a while and you're asking employees to fill out some kind of a form for this type of request, just to make sure that those two are compliant. When it comes to the Pregnant Worker Fairness Act, the EEOC has said you should only be asking for documentation that's reasonable, right? So if they're asking for something related to pregnancy and childbirth, don't ask for all their medical records like over the past 7 years, because that goes beyond the scope of what their request might be. And if you have a standard form that you typically use for disabilities, it may have a lot of questions on there that don't make sense in the context of pregnancy, childbirth, and related conditions. And also with religious accommodations, which is what we're going to talk about next. So the standard for religious accommodations has also changed. There was a significant Supreme Court case, Groff versus DeJoy, and it involved a postal carrier who did not want to work on Sundays due to their evangelical Christian beliefs. And that didn't used to be a problem for them, even though they were a longtime Postal Service employee, because the post office didn't used to deliver on Sundays. But now it even has contracts with private carriers and such that make deliveries on all days of the week. And there was a request made not to work Sundays. The old standard was if it was more than a de minimis burden on the employer did not have to provide that. That would have been enough to constitute undue hardship. And the Supreme Court said, no, that's not enough here. I mean, maybe it's not as high as the bar for a disability accommodation, but you have to do more. And a classic example here to give you a picture of how this might work is the request to swap shifts. So there were cases that said if an employer allows an employee to try to find another worker to fill their shift, that would be enough. That would be a reasonable accommodation. So that's probably not going to cut it anymore. And maybe the employer has to look and see, okay, who else could we schedule to work on Sundays if we have a religious accommodation request? And is it an undue hardship or not? It might be, particularly, again, if your staffing levels are very low, despite trying to get more people onboarded. If it's a holiday time when there are tons of deliveries being scheduled all the time, maybe there would be an undue hardship argument there. But the key, again, is to go through that interactive process and show why the decision was made that it could not be granted if there is a hardship there. And another kind of, this gets into the legalese of this a little bit, but it's interesting in that what the courts have said is that this really should be a case by case decision. There shouldn't be a blanket rule on whether something is going to be accommodated or not. And that also kind of goes to what's in those forms that we're asking employees to fill out. I'll tell you, I had a recent EEOC charge out of Florida where the agency focused on the fact that the employer asked the employee to attach some kind of documentation from a spiritual leader to support the request. That's actually called for in the EEOC guidance if the employer has a reason to doubt the validity of the request, or there's a genuine reason why the employer doesn't understand the request. But the law says, it doesn't really say that you can do that on a blanket basis, right? So the EEOC had a problem with that and said this should be done case by case. It shouldn't be a requirement for everyone to submit this type of documentation. So I thought that was really interesting. So again, we already went over some of these, but take a look at your policies. Do they need to be updated? Do your forms need to be updated? And also think about who's going to be reviewing these requests for you so that they get to that right person. Like Kendra said, you can certainly reach out to the PuzzleHR team. They help with that all the time and are happy to help. Any other questions on that before we move on to our next topic?
Okay. None other in the chat. Yep. So I think we're good.
Okay. All right. So artificial intelligence, and I know you all had a session on this, so I'm going to be pretty brief on this one. This just inserts some humor. This is no legal basis in it, but I just thought it would be fun to ask ChatGPT to write a joke for me. And I asked it why lawyers shouldn't rely on AI. And it said, because if lawyers relied on AI assistance, they might end up with a lawsuit for aiding and abetting the rise of the machines in the legal profession. So that sounds pretty scary. It's not something that I want to do, but I thought that was interesting. There are a whole lot of agencies who have gotten into the game when it comes to AI and what employers should be doing and should not be doing. The National Labor Relations Board has jumped in and basically said that, hey, if you're using any kind of monitoring equipment that would identify whether or not someone is posting about union organizing or any type of protected concerted activity, and you're not hiring those folks or you're disciplining them for that activity, that would be a problem under the National Labor Relations Act. The EEOC has focused on screening out certain protected groups. So if, for instance, you're using a chatbot on your website, but it doesn't account for hearing impaired individuals, perhaps, and so it's screening out that group, that could be a problem. And of course, there are some states and cities that have gotten into the game as well. So make sure that you're aware if you have any local requirements that you might have to contend with. There are a lot of different ways that the EEOC thinks that HR might use AI. I think kind of probably the most common one that I've seen lately are the monitoring tools that identify whether remote workers are actually working, right? So are they away from their computer for an extended amount of time? So maybe they're not monitoring what employees are saying, but it's just the activity going on the computer itself. But then I heard that there's actually a countermeasure to that some employees have discovered called like the jiggler or some funny term like that will move their mouse every few minutes to make it look like they're still actively working. So it just raises the question of if you're going to be using these tools, they do come with some potential liability. So make sure that they're actually beneficial to you and that they're making things more simple rather than more complicated.
That's awesome. Some other areas where we at Puzzle have been able to successfully use AI is making sure that our tone in our emails are professional. So being able to make sure that professionally wrote emails, or even scanning documents to make sure that we're capturing everything that we need to. Being able to collect data, so have a really cool tool that can collect data and be able to provide data for us and readily available. And then also things just as, monitoring and reviewing job descriptions. What is missing out of a job description, what needs to be added into a job description. So AI is here, and had a really cool session earlier, as you mentioned, Deanna, but many different areas where I think even HR professionals can start incorporating AI into their day-to-day work.
Absolutely. I think the other theme from a legal perspective too is just if you're using a vendor, ask the hard questions of the vendor. How are they validating the tool that they're using to make sure that it isn't impacting protected groups? Have they done validation? They should know, hopefully, and be prepared to have information for you on those topics, because unfortunately, we can't just pass the liability on to the vendor. It is going to stay with the employer. So another piece of guidance that we recently have from the EEOC is guidance on workplace harassment. And this is the first time that the guidance has been updated since 1999, which was a very long time ago. It was certainly about time. Some of the key updates included LGBTQ plus rights, making sure that that's expressly noted as a protected area. Online misconduct, that, hey, even if something happens between coworkers on a personal social media website or not during work hours, if it's harassment and an employee complains about that, the employer would need to address it just as if it had occurred in the workplace. Abortion and reproductive choices. I thought this was interesting, and basically saying that reproductive choices can be tied to gender. So that is going to be considered protected by the EEOC at this point, along with pregnancy, childbirth, and other related conditions. If you haven't seen the guidance yet, there's a link there. And I think one of the most interesting parts about the guidance is that it actually has what should be included in a policy. So if you haven't updated your policy in a while, it's good to kind of do a side-by-side comparison. And if you think you're missing something, reach out to the Puzzle team, because they help update those policies all the time. You want to make sure that go ahead.
No, you can keep on. I can kind of hit it at the end.
Okay. No, that'd be great. I love the questions. So keep them coming, by the way. I think it's great to hear what's on everyone's minds, and we really appreciate you taking the time to join us. So ask them if you have them. We're happy to include them. And so basically, when it comes to your policy, you want to define harassment and making sure that you're capturing those updated categories that we just mentioned, and have a reporting process that allows employees to report anytime that you have people working, right? So maybe you do have a designated HR person, but they're only working from 8 to 5, but you have a 24-hour plant facility. Who can they go to in those other hours to make sure they can get concerns addressed at all times when employees are working? Allow them to report to someone other than their direct supervisor, because that person could be the alleged bad actor. And we want to provide multiple avenues, and follow up with people too. Make sure you close the loop after you take the time to do the investigation, so that they know what happened with the complaint. And of course, as always, you want to be prompt with the investigation. And if there is any kind of problem identified, make sure that that is corrected, so that you have a legal defense if an employee does bring a claim, because you can only address what you know about. And then if you take those reasonable steps, again, you would be able to have an affirmative defense if a complaint is filed.
Okay. The question, kind of going back a slide, on the online misconduct. So with the online misconduct, how have you been able to investigate kind of online misconduct to make sure it actually is related to the work and not something separated, and keeping the two separated? Have you had an experience where you've had to kind of navigate that process?
That's a great question. And I can think probably of two different examples. So one would be that, well, let's just call the employee Samantha, right? So Samantha is very active on social media, and she posts things on a regular basis, and she likes to be friends with everybody she knows, everyone she meets. So she's asked several coworkers to be her friend on social media. Some of them have accepted, and then she posts things all the time that might borderline on inappropriate, right? Like maybe she posts things that are derogatory about one religion in particular, and she's constantly posting things about that, and her coworkers are seeing those posts, and they're like, okay, this is starting to get out of hand. We think that this isn't right. We think the company should step in and do something. That type of thing really doesn't have anything to do with the workplace, right? It's one employee sharing their own personal content on social media. And I think you have to take a look at what it is. In most states, as long as it's public information and we didn't, require someone to give us their private password, or we didn't create a fake account to be friends with this person and kind of get the information in a covert way, as long as we saw it and it was open, or employees are coming to us with that information, we can address it if it's something that doesn't align with company policy, even though it's happening outside of work hours. And the only kind of exception to that would be states that have lawful off-duty conduct rules. There aren't a ton of states that have those, but that would kind of be the main thing impacting you if it wasn't unlawful what the person was posting about. But at a minimum, you can have the conversation and just say, listen, it's come to our attention that you are asking some of your coworkers to be friends with you on social media. We've gotten concerns from some of these people that you're posting stuff that's very sensitive. Please keep in mind that if you're choosing to ask coworkers to be friends with you and this comes to the company's attention, then we're going to need to address it, to the extent that we can. Ask those coworkers who have the concern to take screenshots of what they're seeing so that you have evidence, because you're probably not going to be able to log into that account and see those posts, and keep all of that information in case you do need to act on it. Sometimes it's more clear, right? So if someone's posting about something that's illegal, then you can address that. If somebody's posting something that is in clear violation of your policy that actually involves another coworker directly. So let's say that they're sending messages with that same content to an employee who is a member of that religion. Like, I can't believe you're a member of this religion, trying to convince them otherwise, saying bad things. That would fall under your harassment policy, even though it is not happening during work hours, because that's a direct communication between those employees. And I think it becomes a little bit easier at that point because it would fall under your general harassment policy.
All right. Thank you, Deanna. I know anything online and away from work is very complicated and has to be reviewed at all angles. So thank you.
Oh, yes.
All right. Another question we got in is, how does the EEOC deal with the LGBT plus as it is related to employment with religious organizations like non-denominational churches?
So that one gets pretty technical, I would say. So I'm happy to kind of connect with you offline and learn more about like what type of organization are we talking about, what type of employee, what are they hired for? The short answer is there are exceptions for certain types of organizations and certain categories of employees. So we can certainly talk about that.
All right, thank you.
All right, you're welcome. And just a reminder, while we're talking about sexual harassment, some states actually require a harassment policy. It's definitely a best practice to have one regardless, because you want to be able to take advantage of that legal defense that I mentioned. But some states actually require you to have a sexual harassment policy and training as well. So we thought it would be helpful for you to see a map of the states that require sexual harassment prevention training to make sure that you're doing that in those jurisdictions. And you may have heard, I'll just mention this briefly, that diversity, equity, and inclusion programs are under attack. And I think there was a lot of rhetoric in the media surrounding that after a Supreme Court case that involved higher education, which was Students for Fair Admission versus Harvard College and the University of North Carolina, where basically the court ruled that race-conscious admissions policies were unconstitutional. And so there's a question about, is that going to be then applied to employers that have affirmative action programs or diversity, equity, inclusion programs? where they're trying to increase the pool of diverse candidates and thereby the pool of diverse employees in an organization. So there's nothing right now that outright prohibits that. But even that being said, it's something that could be subject to challenge in the near future. So take a look at your DEI policies and programs and your public statements on this issue just to see what is the tone of those policies and those communications. Is it, one protected group versus others, or is it kind of more inclusion in general? And I would be wary, particularly when it comes to race, if your policies and programs are just modeled on white versus other, right? So, because I have seen some programs like that. An alternative might be all races, are valued in the same way, right? So one race could be biased against another race, regardless of which race that might be, right? So just making sure that the tone is on everything as a whole and not just non-minority versus minority when it comes to whites and others. There's also been an anti-woke movement in some states like Florida, where I am. There would have been a training requirement in Florida that basically says that employers can't require certain types of unconscious bias training and DEI training, but that was enjoined. So there is no current rule in Florida that says you can't have that training as of today's date. And I think there were some other states that were moving down that road, but since it got enjoined, that's kind of been put on pause for the moment. Any other questions, Kendra, or thoughts before we change topics?
I think we're good right now. Thank you.
Okay, great. So always like to spend just a few minutes talking about what's new at the National Labor Relations Board. That's General Counsel Abruzzo that we have in the picture here. And she's made no secret on the fact that she is going to be aggressive when it comes to enforcement and trying to make it as easy as possible for union organizing throughout the country. There was a GC memo that she issued with kind of this rhetoric in it that really set the tone of this in 2021. And most of what she had predicted in that memo has come to fruition up to this point. Of course, with handbook rules, those go back and forth because the NLRB is a very political organization. So under the Obama administration, we saw the board really getting into employee handbooks and what things like dress codes, confidentiality policies, media communication policies, standards of conduct, what those type of policies could contain. And then we kind of saw a move away from that under the Trump administration. And now we're back to the very employee friendly view when it comes to that. And so the new standard is basically that if anything would chill an employee from exercising their rights to engage in protected concerted activity, then that could be a problem when it comes to handbook rules, and that they're going to be interpreted from the view of an employee, right? So not the employer, but the employee. Another big change was the confidentiality and non-disparagement provisions in employment agreements. The McLaren decision said that, hey, if we're talking about non-supervisors here, you can't require those broad confidentiality clauses, which were being used by many employers before the McLaren decision came out. And the same thing with non-disparagement. You have to be really careful about what you put in those agreements for non-supervisors there. Just like the FTC, the NLRB does not like non-compete agreements and feels that they are an unfair restraint on non-supervisors. So that's been another kind of main component of the enforcement initiative at the board. Kendra, have you gotten any questions lately when it comes to NLRB activity?
We have, yes, in the Northeast and then in the Western half of the United States, we do have some NLRB activity that we are just working with our clients through right now, and just kind of, it's a process of what we're working on and what we're reviewing at that time. But there has been lately, as of late.
Mm-hmm, absolutely. And that's a great insight too. It is probably going to be heavily dependent on where you are in the country. and also what industry you're in. So if you're just kind of a private employer in Florida, you're probably, knocking on wood, not going to have a whole lot of NLRB activity unless you're in a utilities industry or another type of industry, maybe healthcare, where there's more union activity going on. When it comes to OSHA, so the Occupational Safety and Health Administration, there are kind of a lot of OSHA updates going on. And just a reminder, if you aren't in heavy industry, or you don't have a lot of safety sensitive work going on, you might not have to deal with OSHA very much. So lucky you if you're in that boat. But the OSHA Act does apply to all employers, even if you just have one employee. So keep that in mind. And there is something called the General Duty Clause that OSHA uses to cite employers, because all employers have a duty to keep employees safe from known and recognized hazards if there's a feasible means to abate those hazards. So what am I talking about here? When it comes to things like workplace violence or heat stress, which we'll talk about, those are all areas that can impact you. So like, again, I'm in Florida. So even if you're not in heavy industry, car salesmen and women, for example, they're outside and it's super hot in Florida, and they might be outside for hours at a time showing people cars. And if there's no heat illness prevention plan for those folks, OSHA could view that as a problem. So someone that might not typically think they would be subject to an OSHA inspection, but then they find that they are. So that's why it's important just to kind of remember OSHA and think about what the requirements are. There's been a lot of news lately because OSHA updated its walk-around rule, which is the rule that says employees can have a designated representative in an OSHA inspection that would accompany OSHA during the inspection. Employers can also have their own representative, which might be an attorney or a safety consultant or someone else. And the standard now is much lower for who can be an employee representative. That's what changed with this rule. It can be any third party that the OSHA inspector decides has shown good cause that they're reasonably necessary to conduct an effective and thorough inspection. So that's a pretty low bar. And there's been some concern that, well, what if this is a competitor? What if this is a union organizer, but we don't have a union? Like, what can we do? And what you can ask questions. That's the first thing that you can do, and say, okay, how is this person going to enhance the inspection? What is this person's background? And remember that you have a right to object. So I don't, knocking on wood, again, usually tell clients to tell OSHA to go away, because they will go get a warrant and then they can come in without your consent. And they're usually not very happy when they're required to go get a warrant, because they think the employer might be hiding something. But this might be an instance where it's worth it to say, OSHA, we have no problem with you coming in and doing the inspection, but we have an objection to this third party being here because we don't think there's any good cause for them to be a part of this inspection. So that's always a remedy that's available to the employer. All right. And in our last few minutes here, we've talked about some of these along the way, but we thought it might be helpful just to make sure you're aware of some other hot button issues that are happening across the country. Minimum wage and overtime. So some states have different minimum wages that are higher than the federal minimum wage, like Florida is one of them. Some states have unique requirements for overtime. So maybe it's not over 40 hours in a work week, but it's over 8 hours in a day that would trigger overtime in that state. So very important to make sure that you're aware of what the requirements are to have employees. And the same for the exempt status salary thresholds. Some states have gotten into the game and said, no, we're going to have our own minimum salary threshold for someone to be considered an exempt employee. And that's a relatively new one, I would say, over the past couple of years. So make sure that's on your radar as well. Of course, paid sick leave and family medical leave, those requirements are changing all the time. I think we're over 12 separate requirements in California, depending on where you are in California. So if you're not sure, definitely reach out to the PuzzleHR team. It's, again, something that they deal with all the time because it's very difficult for employers to keep up with the patchwork of requirements across the country. Some other items here, marijuana and drug testing is again something that's very state specific. And with marijuana, we're really seeing a progression, right? So most states start by allowing some form of medical marijuana, and then maybe there's some recreational marijuana. And how does that intersect with what employers can do? I think I can still confidently say that employees are not allowed to be high at work, right? So if someone is showing signs of impairment, you have objective evidence of that, and they test positive for a drug test like marijuana or any other drug, then you're going to be able to take action there if you have the policies in place. Heat stress, that's another one. So there are several states now that have requirements when it comes to heat stress, like California, Washington, Oregon. So make sure you're aware of what those requirements are. Federal OSHA, you're not required to have a written program yet. However, OSHA believes it's a best practice and will probably ask if you have one, if you have employees that are working outside. And these state OSHA plans actually require you to go above and beyond and have a written program with training and other requirements. Child labor is something that's also changing in both ways. Some states are relaxing restrictions when it comes to child labor and allowing 16 and 17-year-olds to do more than they've been able to do in the past. And some states are doing the opposite and putting more restrictions in place for minors who might be working. So if you're using minors, make sure that you know what those requirements are. And I think we already hit on these other issues. So Kendra, are there any other questions that you're seeing or anything else that you're thinking about as we wrap up?
Yes, we have 2 more minutes. So there's some questions that have come through. So if someone's working from home and shows signs of impairment, how do you prove that?
So that is a great question, right? So whoever is interacting with that employee, it's just like if they were in the workplace physically, and you may actually be able to capture more evidence than you otherwise would. I've had it where an employee is seen slurring their speech during a video meeting, and there's an alcohol bottle like behind them, and they don't even realize that it's there in the screen, or they're showing up and they look very disheveled. You can capture that, right? And take a screenshot and grab that evidence that there was paraphernalia in the background or that they weren't dressed professionally for the meeting. But have a plan of what you're going to do, right? So there are vendors out there who will come to that employee's house and do the drug test there. So that way you don't even have to worry about finding an Uber and putting that person in the Uber and taking them to a clinic, but have a plan in place if you've got a lot of remote workers, because the best thing you can do is get them tested as quickly as possible and have that positive test.
All right, thank you. And there are a couple other questions that are coming in, but I think we'll wait on them right now and we'll follow up with anyone that has outstanding questions. We'll respond to you. We'll capture everything. Otherwise, your HR team here at PuzzleHR, we can answer any of the questions as well as they came in, or if you have any questions on any of the trends that you're seeing, either federally or at the state level, you're able to reach out to any of your HR partners here at PuzzleHR. Or Deanna has her information here as well if you'd like a more legal guidance on any of your questions. But really good questions today. And as you can see, there is a lot of stuff out there. So this is just capturing really the last couple months and couple months going forward. And so there's a lot to keep track of, a lot to be on top of. And so if you ever have questions, please ask. And we will also, we have the compliance updates that we can kind of bring you up to speed on what's happening at the state, even down to the local level now, just because things are even trickling down to more of a local level and not just at that state level. So anything else, Deanna, as you wrap up?
I don't thank you. Thank you so much for having me. If you see it and you're looking at the slide deck, we do have a newsletter that's complimentary. So if you'd like to receive updates when we have articles about these topics, feel free to sign up for those and follow us. But I know that Puzzle does an awesome job of keeping you updated on its own. So we're both happy to help you in any way. And I really appreciate you inviting me and spending the time with you. Thank you so much.